Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we crack open United States versus Hemani, and the court just handed the Second Amendment crowd and the marijuana crowd the same win on the same day, June 18th.
9 justices land on the same side here. Prosecuting a Texas gun owner for smoking marijuana a few times a week violates the Second Amendment. Justice Gorsuch writes the lead opinion, and 7 justices sign on to his full reasoning. Justice Thomas writes a solo concurrence about the Commerce Clause. Justice Jackson writes one too, joined by Justice Sotomayor. Justices Alito and Kagan agree with the result but reach it their own way. 0 dissents.
Translation: every justice on this court looked at federal prosecutors going after a guy for owning a Glock while admitting he smoked weed every other day and said, "Not like this. Millions of Americans in legal marijuana states just got real protection from federal gun prosecution."
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. Picture Ali Hemani, 20s, dual citizen of the United States and Pakistan, born and raised right there in Texas. He spends most of his life in the Dallas area, lives with his parents, holds down a steady job. Nothing remarkable on paper. As you may recall from our episode preview, this case actually starts somewhere completely different from where it ends up. Federal agents searched the Hemani family home in 2022 over suspected terrorism-related activity. Not drugs, not guns. Terrorism.
And Hemani cooperates with every step of that search. He hands over a Glock 19 he keeps in the house. He points agents straight to marijuana on the property. He sits down for an interview and tells investigators flat out that he smokes marijuana about every other day.
Agents also find cocaine in his parents' closet. Hemani claims that too, though he says his mother hid it there and he didn't touch it recently. Here's where it gets interesting. More than 6 months pass, and when the government finally brings charges, the terrorism investigation goes nowhere. No trafficking charge, no cocaine charge, nothing.
So what's left to charge him with?
1 count built entirely on his own words, owning a gun while qualifying as an unlawful user of a controlled substance under 18 U.S.C. Section 922 G3. This federal law strips gun rights from anyone who regularly uses an illegal drug, period. No proof of danger required. Penalty: up to 15 years in prison and a lifetime gun ban. And prosecutors never claim Hemani struggles with addiction. They never claim his marijuana use endangers himself or anyone else. They never even claim he did anything with that gun beyond simply owning it.
We dug into this exact tension when we sat down with Adil Bashir, federal public defender and amicus brief author, right before oral argument. Adil framed this case as a collision between 2 massive legal doctrines: the individual right to bear arms under the Second Amendment and the broader question of whether America criminalizes too much ordinary behavior. I'll link to the interview in the show notes.
He put it perfectly. Guns and weed, 2 things a whole lot of Americans love, suddenly combining into a 15-year felony.
Let's move through the courts fast, because the path here twists hard. Hemani moves to dismiss the indictment on February 15, 2023, arguing this prosecution violates the Second Amendment under the Supreme Court's Bruin decision. That's New York State Rifle and Pistol Association versus Bruin, a 2022 case that swapped the old balancing test approach for a show me the history test. A federal magistrate judge agrees with Hemani right out of the gate. Then, while this case sits pending, the Fifth Circuit decides a similar case, United States versus Daniels, and strikes that same provision down as applied to a non-intoxicated user. The district court grants dismissal on February 1st, 2024.
As longtime listeners remember from our episode preview, this kicks off a wild chain reaction. The Supreme Court decides United States versus Rahimi in 2024, a case upholding a different gun disarmament law tied to domestic violence restraining orders. The court sends Daniels back down for a second look, the Fifth Circuit doubles down in United States versus Connolly, and the government throws in the towel on Hemani's case too, conceding it on September 16, 2024. The Fifth Circuit accepts that concession on January 31st, 2025. The government petitions for Supreme Court review, the justices grant it, and the case lands in the courtroom March 2nd, 2026.
So, here's the actual question the court takes up. Does Section 922 G3 violate the Second Amendment as applied to Hemani?
Plain English. Can the government strip someone's gun rights just because that person regularly uses a banned drug with zero proof of danger?
And the statute splits into two separate paths, which came up directly at oral argument. Justice Gorsuch presses the government's lawyer, Sarah Harris, on this exact point. The law bans both unlawful users and people addicted to a controlled substance. He wants to know what's left of the addiction half if unlawful user already means habitual user.
Funny enough, Adil Bashir flagged this exact ambiguity in our preview interview, before oral argument even happened. He walked through how the Controlled Substances Act sets up 5 drug schedules. People picture heroin or fentanyl, but those schedules also sweep in cough medicine, steroids, Xanax, and marijuana.
Adil even built his own hypothetical to get listeners thinking about what user really means. He asked, if I use a credit card I almost never touch, just once for the points, does that make me a user of that card? If I drink green tea for the first time since the Bush administration, does that make me a user of green tea?
That ambiguity drives the entire case. The government reads unlawful user to mean habitual or regular use. Hemani's side argues that interpretation invents words Congress never wrote. And either way, the statute doesn't require proof the person poses any actual danger. Convictions under this exact provision account for roughly 5% of all federal gun possession convictions nationwide. So the stakes here stretch well past one guy in Texas.
Walk me through how the court actually gets from question to answer.
2 cases set the framework. First, Bruin, 2022, swaps old balancing tests for a find me history approach. Second, United States versus Rahimi, 2024, which clarifies the government doesn't need a historical twin, just a law from history that's relevantly similar in why it existed and how it worked.
Translate why and how for me.
Why asks, did the historical law target people for the same underlying reason the modern law does? How asks, did the historical law actually operate the same way? Who decided? What process happened? What punishment followed? The government concedes upfront that Section 922, G3, burdens a constitutionally protected right. So the burden lands on the government to prove the historical match.
And what's their historical match?
Habitual drunkard laws. 3 flavors: vagrancy laws that let towns lock up drunkards in workhouses, civil commitment laws that let courts appoint guardians or commit drunkards to asylums, and surety laws that force drunkards to post bonds for good behavior. Sarah Harris leans hard into this at oral argument, opening her remarks by insisting the Second Amendment doesn't block temporarily disarming habitual marijuana users, calling it a restriction that easily fits within the historical tradition.
Easily, huh? The justices don't sound convinced. I remember Justice Sotomayor pouncing on that word almost immediately.
She does. Sotomayor asked Harris point-blank whether the government's theory would let it ban guns for homeless people too. Just vagabonds, she calls them. Harris says no, but Sotomayor keeps pressing. She points out that habitual drunkard never just meant drinks regularly. It meant someone so consistently intoxicated they couldn't function, couldn't hold a job, couldn't care for family.
And the written opinion runs with that exact distinction, and it digs up some genuinely fun, albeit troubling history to prove it. John Adams drank a tankard of hard cider with breakfast daily. James Madison reportedly put away a pint of whiskey a day. George Washington worked through 3 glasses of Madeira most evenings. None of these guys ever qualified as habitual drunkards under the laws the government cites, because those laws demanded actual incapacity, losing the power of self-control, becoming incapable of conducting one's own affairs. So regular use, even heavy regular use, never triggered these laws back then. Only total incapacity did.
Exactly the gap the court calls fatal. Hemani's lawyer, Erin Murphy, hammers that same gap in her oral argument opening. She calls the government's theory a category mistake. Since the historical laws targeted habitual drunkards, meaning incapacitated people, not habitual drinkers, meaning people who simply consume regularly.
Okay, what about the government's claimed reason, protecting the public from dangerous people?
Same trouble, different angle. Vagrancy laws mostly punished idleness and enforced work norms. Civil commitment laws protected drunkards from wrecking their own finances, not the public from violence. And the surety laws the government cites here, different from the surety of the peace laws Rahimi upheld. Targeted general scandal, not violent threats.
And the how?
Here's the kicker. Every single historical law required process before anyone lost a right. A conviction before jail, a probate hearing before guardianship, a hearing before a justice of the peace before a bond. Section 922, G3, skips all of that. It strips your gun rights the instant you become a regular user. Automatically, no hearing first.
That echoes Justice Barrett's ambient hypothetical at oral argument. Barrett poses this great real-world scenario to Harris. A husband holds a legal Ambien prescription. His wife doesn't. One night, she grabs a pill from his bottle to sleep. Under the government's theory, the wife instantly becomes an unlawful user. Same drug, same household, same medicine cabinet, purely on a paperwork technicality, not anything about Ambien itself making her dangerous.
That's such a clean way to expose the flaw.
Barrett pushes further too, asking Harris about a college student borrowing a roommate's Ritalin to cram for an exam. The written opinion picks up that exact thread and builds its own version. A husband borrowing his wife's Ambien. A student borrowing a friend's Adderall, to show how far this any drug, any amount theory really reaches.
And then there's the marijuana rescheduling twist. Marijuana sits on Schedule 1, the harshest category, when the parties argue this case in March 2026. Mid-litigation, the government actually moves marijuana to Schedule 3. Justice Gorsuch calls this out directly at oral argument, basically asking Harris why the government chose this case as its test case while simultaneously rescheduling the exact drug at the center of it.
Awkward timing.
Very. The written opinion runs with that same point. The Justice Department spent over a decade telling federal prosecutors to ease up on marijuana enforcement. 40 states legalize marijuana to some degree, and more Americans reportedly use marijuana regularly than alcohol today. That history makes it tough for the government to argue marijuana users count as categorically dangerous. So, bottom line, what's the actual holding?
The court holds that the government's prosecution of Hemani under Section 922 G3's unlawful user provision fails the history and tradition test because the habitual drunkard analogy targets different people, for different reasons, through a different process than the modern statute uses. The court affirms the Fifth Circuit's judgment. Justice Gorsuch writes for a full 7-justice majority. Translation, Hemani keeps his win. The indictment stays dismissed.
Now, let's walk through the separate opinions, because there's a lot going on even though nobody dissents.
3 justices write separately, starting with Justice Thomas. He joins Gorsuch's opinion completely. No daylight between them on the Second Amendment analysis. But Thomas uses his concurrence to raise a totally different constitutional problem. He thinks Section 922 G, the entire provision, oversteps Congress's power under the Commerce Clause, Congress's constitutional authority to regulate trade between states.
What's a gun in a guy's own Texas house got to do with interstate trade?
That's exactly Thomas's point. The government only needs to show the gun crossed a state line at some point, ever, in its entire history, even decades before Hemani bought it secondhand. Thomas calls that something far short of regulating actual commerce. He revisits Scarborough versus United States, a 1977 case, and argues lower courts misread it for decades. Scarborough only settled a statutory question about what counts as commerce under the text, never the constitutional question of whether Congress held the power to pass this law in the first place. He stacks up a long list of frustrated lower court judges who say the same thing.
So, Thomas agrees Hemani wins, but he wants the court to eventually blow up the whole foundation of federal gun law. He explicitly invites a future case to test this theory. Nobody else signs onto this part, so it carries zero binding weight right now. But it puts every federal prosecutor on notice that at least one vote on this court doubts the constitutional foundation under a huge chunk of federal gun law.
Next up, Justice Jackson, joined by Justice Sotomayor. This one goes after the whole rulebook. Jackson joins the majority opinion in full too, but she uses her concurrence to renew an argument she's made before. The entire Bruin history and tradition framework just doesn't work. She'd rather courts return to means and scrutiny, the pre-Bruin approach where judges weighed how badly a law burdens a constitutional right against how strong the government's justification runs. Stronger justification, more burden allowed. Weaker justification, less burden allowed. Straightforward math, basically.
And this came up live at oral argument too, right? I remember Jackson grilling Deputy Solicitor General Sarah Harris hard on exactly this. At one point, Jackson tells Harris flat out that she doesn't follow how the test even works anymore post-Rahimi, and asks how means-end scrutiny folds into the history approach at all. Harris insists it never folds in. History alone carries the whole analysis. Jackson pushes back. Then how does any of this avoid collapsing into simply trusting whatever Congress says about who counts as dangerous?
Justice Jackson's concurrence picks that thread back up. She points out that even the majority's own why and how analysis quietly smuggles in tailoring questions that sound a lot like means-end scrutiny anyway, proof, in her view, that the current framework can't even follow its own logic consistently. Practically, this signals that if the right case comes along, at least two justices stand ready to scrap Bruin altogether. That's a real crack for future Second Amendment litigators to aim at.
Last one, Justice Alito, joined by Justice Kagan, concurring in the judgment only. Odd pairing that you don't see often. Quick definition for listeners, concurring in the judgment means you agree who wins, but you refuse to sign on to the majority's reasoning to get there.
Much narrower path here. Alito skips most of the majority's sweeping historical survey and zeroes in on one gap in the government's proof. Nobody knows how much marijuana Hemani actually used, its potency, how often per day, or whether it ever affected his judgment.
Historical, habitual, drunkard laws only ever disarmed people whose use left them genuinely incapacitated. And the government never even tried to show Hemani's use did that to him.
That connects right back to the Sotomayor exchange. Incapacity, not just regular use.
Exactly. Alito leans into that same idea from a different angle. He draws his own analogy. Marijuana today, he argues, looks a lot like alcohol at the founding. Widespread, increasingly normal, something law enforcement mostly looks past. Because of that, he'd rather decide this case on the thin, factual record alone, skipping the majority's broader history lecture. That narrower path gives future courts an easier off-ramp in cases with a thicker factual record.
And to keep this straight for listeners, no dissents at all here?
None. Every single justice lands on the same side. The disagreement runs entirely about the road they take, never the destination.
Time for our favorite part of the show, what this actually means. For starters, every regular marijuana user in a legal marijuana state who also owns a gun just got real breathing room. Federal prosecutors can't bring a Section 922 G3 charge based purely on this person uses drugs regularly. Full stop. They need something more, real evidence tied to addiction, intoxication, or actual danger.
And that ripples out wide. 40 states carry some form of legal marijuana on the books today, with millions of gun owners who also happen to use cannabis.
This connects directly back to our preview interview with Adil Bashir. We asked him to fill in the blank. What happens if the government wins, and what happens if Hemani wins? He nailed exactly what plays out here. He predicted a Hemani win would mean the court treats the Second Amendment like other constitutional rights, forcing the government to tailor its historical analogy tightly instead of arguing by loose generality.
That's basically word for word what Gorsuch's opinion delivers.
Right down to the letter. But Adil also flagged a third possibility, that the court might take a narrow path and leave plenty of questions open for another day. That prediction lands too.
What's still open?
Plenty. The court explicitly doesn't touch bans on people legally classified as addicts or people actively intoxicated when caught with a gun. It doesn't address whether Congress could pass a narrower, evidence-backed law targeting one specific drug Congress can actually prove makes its users dangerous. And it doesn't touch Section 922 G1, the separate felon disarmament provision, at all.
So expect more lawsuits. Defense attorneys nationwide just got a blueprint for challenging similar prosecutions, especially anyone charged the way Hemani got charged. Admitted regular use, zero evidence of danger. Keep an eye on the Commerce Clause angle Thomas opened up too, plus whatever happens next with Justice Jackson's ongoing campaign against the Bruin test itself.
Bottom line,
the government tried to turn "I smoke weed a couple times a week" into an automatic 15-year felony and a lifetime gun ban, with zero proof of danger required. 9 justices said that goes too far.
And whatever you think about guns or marijuana personally, this case stands for something bigger. The government must do its homework before it strips away a constitutional right. No shortcuts, no guesswork. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Honestly, at this point, subscribing to this podcast carries way less legal risk than half the stuff we covered today.
Genuinely the safest habit on this entire episode. Talk to you soon.